So good morning, everyone. Welcome to this Workforce Wednesday webinar. My name is Kirsten Bayer with the Illinois Center for Specialized Professional Support at Illinois State University. I will be your moderator and technical support for today's session. Today's Workforce Wednesday webinar is WIOA Dislocated Worker Eligibility, and I'm joined by Jim Potts, and he's going to be our presenter for today. Before we get started with him, I'll let him introduce himself. Just a couple of housekeeping items. So Jim, if you want to go to the next slide for me, please. So this is me. I'm the Digital Communications Manager at ICSPS. Hopefully you've heard of our center by now. We work very closely with Illinois WorkNet and other WIOA partners. Here's my email. If you need anything following this session, feel free to reach out to me. You can also reach out to me via the chat today or the Q&A function. I will be monitoring both of those. We are on Zoom webinar today, not Zoom meeting. There is a difference. The biggest being that you as attendees cannot unmute yourselves and you cannot turn on your cameras. So it's a little bit more close-ended for a presentation. We do have the ability to unmute you if you would like to raise your hand towards the end. But I think we're going to ask that if you have a question or comment or concern to just participate in the chat or the Q&A, and I'll help Jim facilitate that. We will have time for questions throughout and at the end of the presentation when Jim pauses. And then if we're not able to get through all the questions today, we will be putting out an FAQ if that's needed. We don't think it's going to be needed, but if it is, we will be more than willing to do that. Some other housekeeping things is that this session is recorded. It's going to be up on our Illinois Workforce Academy website and Illinois WorkNet's website. It typically takes about 48 working business hours to edit the closed captioning and edit anything else out of the video we need to. So please allow for that time. I will put the website where the recording will be up at in the chat here momentarily, and then the presentation slides are also available to you on that website. So I'll have all that in the chat here just in a second when I'm finished talking. You will also be receiving a follow-up email tomorrow that will have the URL where the recording will be and the presentation are. And then also you will have a follow-up survey. We just ask that you take a couple minutes out of your workday to take that follow-up survey. I'm also going to put the same follow-up survey in the chat at the very end of today's webinar. I know whenever I watch a webinar, I'm not going to take a survey unless it's like right away while the session is fresh in my mind. So I always like to give you guys the opportunity to do that. But if you don't have time to do that today, you will have it in your follow-up email tomorrow. So Jim, if you want to go to the next slide for me. So we do our beginning Workforce Wednesday webinar poll. So I'm going to go ahead and launch those. They're both going to launch at the same time. So you can just scroll and answer questions 1 and 2. The first question is, where's your local area? So where are you joining us from today? And then the second question is, which partner do you best represent? So Title 1, 2, 3, 4, or if you're another WIOA partner, stakeholder, or state or local workforce innovation board member. And then we also do have closed captioning on today. So if you would like to turn that on, you can see it's on Jim's screen. So you can turn that on and use it for note-taking purposes or accessibility reasons. We'll give everyone a couple more seconds here to answer the polls, and then I'll debrief them. Jim, you can go to the next slide if you want to, because both polls are up right now.
Not letting me advance for some reason. I'm locked up here, Kristen.
If you click on it, it won't let you advance?
Nope. I'm trying the page down. I'm trying the arrows. Just how I advanced a while ago is not letting me do it now.
If you hover over in the left, yeah, there you go. There you go. Perfect.
Oops.
Okay, so I'm going to go ahead and end the poll and then share the results. We'll kind of debrief here. So it looks like most of you are joining us actually across the state. Wow, we actually have a lot of people even down south and in central Illinois too, as well as Chicago and northern Illinois. So thank you for joining us. all across the state this morning. And then most of you are from Title I, and then we have a couple from Title II and Title III. So thank you for joining us. We do appreciate you taking the time to answer those for our analytics, for our reporting purposes. And if you need anything, I will be here the whole session. So feel free to reach out to me via the chat or the Q&A. And I'm going to hand it off to Jim to introduce himself.
Good morning, everyone. My name is Jim Potts. I work for Illinois Department of Commerce and Economic Opportunity in Springfield. I've been there all the way since '06 in the same capacity. So it seems like it's been forever. Probably because it has, I guess. So now we're going to get into the actual presentation of why we're here today. So the objective of this presentation is to inform you folks about the intricate details around the updated WIOA, Workforce Innovation and Opportunity Dislocated Worker Eligibility policy that was released recently. It was released back in January on the 27th. This is just a top of a view of what the policy is. Those of you that's on this email or in this webinar should have received an email from me this morning that actually gave you the hard copy of the dislocated worker policy, as well as the attachments that go with it. I myself find having that hard copy is kind of handy versus looking at it online, but yeah, for your choices. So
Jim,
some of the other,
I'm so sorry to interrupt you, but it looks like most people are having a little bit of hard time hearing you. Are you able to speak more into your microphone?
I will do that. Yep, I'll do that. Is this better now?
I can hear it, but everyone's saying it's a little scratchy, but is that okay? They're saying it's better. Yeah.
It's probably not going to get much better than this because sometimes my computer doesn't work as well as we would hope, I guess. Guess that's part of the virtual stuff, huh? But back to the authorities for this presentation, besides that new policy, you have the legislation itself, and then the federal guidance. For those of you who might be newer, all of the guidance that the state has could be, if it was, we generate that either from the WIOA legislation or based on input from the Training and Employment Guidance Letter, Teagle 1916, that comes from Department of Labor. Then we also have our general eligibility, which is just every client, regardless of which title, you must meet general eligibility, as well as selective service requirements, which is part of general eligibility. And then, of course, that new policy on dislocated worker. So for the general eligibility, all clients, again, regardless of which title, they must be authorized to work in the United States. And also, if an individual is born male who turned age 18 on or after, it's actually supposed to be January 1st, 1960, must be compliant with selective service. Now, under the dislocated worker eligibility, you'll notice that in our new policy, there's now 6 different categories where an individual could be determined eligible as a dislocated worker. And we'll end up going in depth on each one of these, but just as an overview, we have unlikely to return to previous industry occupation, plant closure or substantial layoff, UI profilee, no longer self-employed, displaced homemaker, and spouse of a member of the armed forces on active duty. The newest one that we added is this UI profilee that I'm really excited about. Well, one of the things also within the new dislocated worker policy is Department of Commerce has put in a checklist, and it's part of the attachments that was included to what I emailed out this morning. And it's the 3rd attachment, so I call it attachment C. And it's just the dislocated worker eligibility checklist, which is just a truncated wording of the 6 different eligibility criteria. Some of the folks in our audience today use Illinois Workforce Development System, IWDS, and others use a system called Career Connect for recording their WIOA applications and has the eligibility within. So LWIA 7 up in Chicago and all the service providers that are sub-grantees for the Chicago Cook County workforce utilize that Career Connect system. And then all other LWIAs around Illinois use the IWDS, Illinois Workforce Development System. During the presentation today, we'll be discussing the updated WIOA dislocated worker policy, and much of the presentation will be demonstrating how the clients are portrayed within IWDS, as IWDS correlates directly to how that dislocated worker criteria associated with the current policy as well as the federal guidance. But what I did do is I brought in the Career Connect. They have a really good Career Connect checklist. So I brought in that criteria, how it relates, because under Career Connect, they break the dislocated worker down into 8 different categories. So for those of you who don't work with Career Connect, you get a little bit of idea what they deal with. And for those of you that do work with Career Connect, you'll get to see the IWS system, which your application in Career Connect actually feeds into, because IWS is the state's federal reporting that they send to the Department of Labor. Regardless of which system you use, whether it's IWS or Career Connect, there's some key term items that must be understood related to dislocated worker eligibility. And those are the terms of underemployed, self-sustaining employment, and intervening employment. Intervening employment, some people know it as called stopgap employment. And we'll touch on each of these 3 definitions. You'll also notice that the term underemployed is included as part of various WIOA dislocated worker eligibility criteria. Under WIOA, underemployed is defined as an individual who is working part-time but desires full-time employment, or who is working employment not commensurate with the individual's demonstrated level of educational attainment. We have the Teagle 1916, the guidance from Department of Labor, that also states that if an individual is working full-time but is on public assistance, so if they're receiving food stamps or cash welfare or medical assistance, then they should also be considered underemployed. And that makes a lot of sense. If somebody's working a full-time job, but they have to be on public assistance, then we need to hopefully help them get a better job. Under Teagle 1916, it's also provided guidance that individuals who meet any WIOA low-income criteria but are working full-time are considered underemployed. Meaning, so if somebody has an income calculation that determines as low income, they should also be considered underemployed. And then similar, each LWIA has the prerogative to define self-sufficiency criteria for a dislocated worker based on the individual finding employment that's equal to or greater than a percentage of a dislocation layoff wage. If you have those type of guidance, you could also be considered somebody underemployed who's working a job that's below the self-sufficiency criteria of your own local area's policy. With an IWDS, it's on the employment characteristics screen, there's the question underemployed. And so any client that you have that is underemployed, it should be indicated, but also I purposely did this slide this way. You notice the person is listed as unemployed. Well, somebody who's unemployed should not be considered underemployed at any time. So it's an example of what we really shouldn't do on this case. So a person should be employed in order to be underemployed, but it is a key to indicate those who are unemployed, because it doesn't have straight up eligibility, but it is a barrier for employment that's reported to Department of Labor for all titles. So if you have an adult or a youth or a dislocated worker who's underemployed, please make sure you annotate accordingly in the application, because you'll get credit for that as well as for the statistical adjustment model for having that barrier. So now let's speak about self-sustaining employment. What that is, the job that meets the LWIA's definition for self-sufficiency. As I mentioned earlier, under the dislocated worker title, each LWIA has the latitude to define self-sufficient employment based on a percentage of a dislocation wage. And myself, I would highly recommend this to local areas. And the reason why, it helps your higher earning folks that get dislocated. If you're dislocated from a higher earning job, if we're going to base getting them back to an employment based on a percentage of a layoff, whether it be 80 or 85 or 90 or 95, some LWIAs even have 100%. It gives you guys a lot of flexibility to continue serving those folks if they have to take jobs below self-sufficiency. At a recent in-person WIOA eligibility dislocated worker training with LWIA 23, they provided their guidance on self-sufficiency. So I'm just going to use that as an example. And theirs is set at 95% of the customer's wage at dislocation, or at their adult level for self-sufficiency, which is 185% of the current lower living standard income level, the LLSIL, whichever is greater. I think this is a really good, solid self-sufficiency criteria for a dislocated worker, because it allows those folks who have a higher wage to be based on 95% of the dislocation wage, but those who might have been dislocated from a lower wage, if they have employment below 185% of the lower LLSL, they could use that too. So using the example on that previous slide for a dislocated worker, that would be from LWIA 23, where the self-sufficiency criteria for the dislocated worker is set at 95% of their dislocated wage or 185% of the LLSIL, whichever is higher. If a client would be making $50,000 per year at dislocation, and that individual was hired into a job making less than $47,500 of their dislocation wage, which is that 95% of the dislocation wage of 50 grand, then that new employment could be considered intervening employment or stopgap employment. So this is just a question to think about for yourselves. If you are currently working as a career planner with the dislocated worker policy or population, and if you do not currently know your own LWIA's local guidance / policy on self-sufficiency for dislocated worker, I highly recommend you speak with your supervisor to get the information on what is your locally defined self-sufficiency criteria for a dislocated worker. Because without that information, it makes it extremely difficult for you as the career planner to know what the overall goal is in relation to assisting your dislocated worker clients in obtaining that full-time self-sustained employment. So to tie everything together on these topics, if a client had intervening employment, they would also be considered underemployed. The client could still have consideration for eligibility under the dislocated worker program using that original dislocation job while working at that intervening employment due to the job being underemployed. Lastly, on this topic, a client would be working in intervening employment at any job until they obtain self-sustained employment. So hopefully everybody understands those details. And now we're going to get into the specific eligibility that's covered in the updated dislocated worker policy. As I mentioned, there are 6 different ways someone could be determined eligible. Often you might find people that fall into multiple categories. Often the person could be part of a plant closure substantial layoff that's also unlikely to return. Often people that are spouse of an active duty service member, they'll often also meet displaced homemaker. Also people who are no longer self-employed, they often also meet unlikely to return. So you can see some cross-pollination, but what you got to realize for your eligibility, you just need your client to be eligible one way. So you don't have to certify them if they're eligible for multiple dislocated worker titles. Just use what's easiest. So a lot of times plant closure substantial layoff is much easier than unlikely to return. So if the client's eligible for that, you'd want to pick the plant closure substantial layoff. So again, whatever's easiest for you as well as the client to not make them bring in a bunch of documents if they don't need to. One of the things I'm going to transition now over for Career Connect. Those of you who work in LWIA 7, Career Connect has a really excellent checklist that they provide for the dislocated worker that helps correlate over those 6 different criteria into those 8 different criteria that's in Career Connect for dislocated worker under categories 1 through 8. Besides the guidance in the federal and state policies, each LWIA has latitude to establish additional local policy guidance, and Chicago Cook Workforce Partnership does an exceptional job conducting tailored virtual trainings and webinars for their staff, and then they record those and put them at the link. So for those of you who work with Career Connect, hopefully you're familiar with this link that I'm sharing here, because if you have any specific questions about Career Connect, you definitely want to go through the Zendesk versus the consideration about IWDS since you're working with the Career Connect system. Now what we'd like to do is take a little poll to find out the attendees for today, who uses IWDS, how many use Career Connect, and then for some of you who maybe aren't working directly with clients, then I gave an option of I do not create a WIOA dislocated worker applications. If you guys could take a moment and give your feedback on that, just let me kind of have an idea of the breakout of folks. And then once that survey is completed, then we're going to move on. So go ahead and give you a few more seconds to put your answer in. And again, just one answer, either use Career Connect or IWDS or you don't build them at all. And then what we're going to do now is we're going to shut that one down and move on to the next slide. So good, that's a good breakout. It's kind of about what I expected. The majority for IWDS, but a good group from LWS 7 that use Career Connect, and then a few folks that don't do day-to-day applications. So that's kind of what I was expecting. So it's good to see. Thanks for sharing that. So now let's get into the specific policy on the dislocated worker title. The first is unlikely to return, we're going to cover. It's by far the most complex. And in the new policy, it was updated wording. The wording is, has an individual been terminated or laid off or received a notice of employment termination or layoff? And this would include an individual who has separated from or has an impending separation from the armed forces. And the next portion, and again, unlikely return is a very layered eligibility. So you first identify they're going to be laid off. The next portion for unlikely to return, the policy speaks about is eligible for or has exhausted entitlement to unemployment compensation as documented in one of the following ways: insurance benefits. And the next paragraph, it's legal talk, and it talks about the classifications of person as eligible for unemployment compensation is limited to those who have been determined to receive a monetary benefit by the state's unemployment insurance administrative agency, or who have been determined by the state's unemployment administrative agency to have exhausted their benefits. So what this is basically saying is, in order to be unlikely to return, if a client worked at a job that had paid into unemployment, they're required to be able to either draw a monetary UI benefit or exhausted their benefits. So that's the first step we have to understand under unlikely return. If they worked at a job that paid into unemployment, they have to be eligible to draw a monetary benefit. Traditional UI payments, unemployment insurance, are received when an individual loses their job where the employer of record had been paying into the UI system on behalf of that individual. When the individual applies for UI, if the employer does not dispute the UI claim, the individual is able to draw a UI benefit while looking for new employment. What we see sometimes occur is a person will apply for unemployment and they receive a benefit, and they might even receive their first check, but then the employer states to IDS, Illinois Department of Employment Security, hey, this person, we don't think they should get unemployment, and then IDS stops that payment. That's what happens a lot of times, or sometimes with our clients, where you'll see folks that are on it and then they're not. Well, if that happens to your client, they need to fight that adjudication process, because they have to be eligible to draw that monetary UI benefit or exhausted if they worked at a job that paid in. Now, if for some reason why you put them in the dislocated worker unlikely return prior, and you had the documentation that showed they'd gotten that benefit, and you can prove it with your documentation, then they're in. And if it gets taken away at a later date, then you have to prove it at time of application. So that's some consideration. But one of the things we've made, and you'll hear it a little bit later in the presentation, is we've broadened the term of a substantial layoff. So what we could find is some of those people who get denied UI, that they might now meet the substantial layoff. So keep that in mind when we start talking about this a little bit later in the presentation. Now, also another thing I want to pass on, in the past, there's been a lot of information about different types of UI payments. There was this thing called Pandemic Unemployment Assistance, the PUA program, that was going on during the COVID crisis, which provided UI benefits for many individuals who had been determined ineligible for traditional unemployment benefits. These were typically self-employed folks, independent contractors, probably the two most well-known groups that end up receiving the PUA when the COVID was going on. So regardless if the individual receives or had received traditional UI benefits or PUA benefits, or are receiving or is eligible to receive a monetary but not currently drawing, or they exhausted traditional UI or PUA, they would meet this portion of the criteria for under UI for unlikely to return. Again, another key point to understand, regardless if the individual was fired, quit, or laid off, if they're determined eligible to draw a monetary UI benefit, either traditional or that PUA, or has exhausted their monetary UI benefit, either traditional or UA, the criteria tied to being determined terminated or laid off is met. So that UI means so much for unlikely to return. Back in September of 2021, the Pandemic Unemployment Assistance, PUA, ended. And there were a lot of questions related to how a client who was on PUA when the program ended should be recorded within their WIOA application regarding UI status. So what happened is our policy unit reached out to the folks at Illinois Department of Employment Security, IDS, and it was determined based on UI law, if an individual was drawing PUA when the program ended, even if that individual still had a balance remaining when the PUA ended, the individual should be considered to have exhausted their benefits. So that's a good, it helped folks. That was a good determination in my eyes. That question, we put that question and answer on the OET COVID-19 Q&A that's on WorkNet, and it's just under the frequently asked questions. So it's question number 22 with that question and answer for those of you who need to or would like to go back and look at that. Where it's captured within IWDS, it's on the employment characteristics screen. It has this question of UI status. And under UI, you can have eligible but not receiving, exhausted benefits, not eligible, not determined, receiving benefits. If a client has any response other than not eligible, not determined, they would be able to meet this portion of the criteria. So if they're eligible but not receiving, they've exhausted, or they're currently receiving, it's a positive for passing this portion of the eligibility criteria. But whatever they state there, you must have documentation at time of certification to support that answer. So that's a key to make sure everybody understands. Now, for those of you who utilize Career Connect for the dislocated worker criteria of unlikely to return to previous industry occupation, where the client had worked at a job that had paid into UI, and the client is eligible for or had exhausted their UI, the client would fall under Category 1 within Career Connect. And here's the portion out of the checklist that speaks about Category 1. So to recap, the initial eligibility for unlikely return to previous industry occupation requires that the client be eligible to draw a monetary UI benefit, either traditional UI or PUA, or exhausted either traditional UI or PA. So that's what we covered previous. Now, in addition, there is an alternative to UI for individuals who worked at an employer who had not paid into UI on behalf of the employer. This is known as tenure. The details around tenure will be covered in the next several slides. And this is how it's worded in the policy. So this is a good change that was made in this policy. In the past, in order to meet the tenure criteria, somebody had to work 6 months in the industry or occupation to be considered under the tenure. That's been downsized to now the person only has to work 30 days in the industry or occupation from which he or she was dislocated, but is not eligible for unemployment compensation due to insufficient earnings or having performed services for employer that were not covered in the state's UI law. I could foresee people that had worked that had worked just a little over days who might not be eligible to draw due to those insufficient earnings. So that's something that might benefit some of our clients in the past we've had to turn away. Tenure is for an individual who worked at a job or in the industry for at least 30 days where the employer did not pay in the UI system on behalf of the employees, or if they worked at the job for 30 days and they had insufficient wages. That's the only time it can be utilized. So if somebody, again, worked at a job that paid in to UI, then this tenure is not in play. It's only for those two situations there. However, if somebody worked at a job that did not pay into UI and they worked at least 30 days at that occupation and or industry, they would meet tenure. And as mentioned earlier, that tenure now is 30 days. So to me, this is a really good change that we've had. Another group of people that could fall into this that I was thinking about, that somebody who's maybe on workman's comp, they're tied to a job, but the employer's not paying in because the individual's on workman's comp, and then they get laid off. So that would be another person that could fall under tenure. Often also people who separate from the armed forces, they're discharged that are not eligible for UI. Then the folks at IDS has given guidance that those people would meet tenure if they had served at least 30 days in the armed forces and are not eligible for UI. So again, this is helping those folks who are getting out of the armed forces or have gotten out, not obtained full-time self-sustained employment. Where the tenure is captured, it's on the employment characteristics screen. It's a simple question, tenure, yes or no. So it's on the career planner to know those details that's in the policy that we just discussed about what it means to meet the tenure. And if we have a yes to that question at time certification, then since it's the alternative UI for unlikely return, if you're trying to make your client eligible on unlikely return, you'd have to have documentation to support the tenure. Some examples of jobs that typically fall under the tenure are folks that work at churches or religious organizations. The railroad, they have their own UI system, so they wouldn't be on traditional UI. Insurance agent, don't think big State Farm, Allstate, more mom and pop insurance agencies. Typically nobody's paying into insurance on their or in the UI on their behalf. Folks that work for farmers, agricultural labor, domestic services, a lot of small family businesses. Many of the jobs of those jobs did receive PUA during COVID, but to my knowledge, again, the PUA ended in 2021, September. Now, for those of you who work Career Connect, it's for those who meet the tenure portion and unlikely return, they fall under category 2 of Career Connect. So again, category 1 in Career Connect is for unlikely return for those who had worked at a job that paid into UI and they're eligible to draw or exhausted it. Category 2 in Career Connect are for people unlikely return that worked at a job that did not pay into UI or they had insufficient wages to draw. So that's where that comes into play. It's very important to understand that under the criteria of unlikely return, if an individual is laid off or fired or quit from a job where the employer had paid into UI system on behalf of the individual has been denied UI, either both traditional UI or PUA, the individual cannot be determined unlikely return. There is no exception to this paragraph. So that's a really key to understand about unlikely return. So now the person's still not eligible for unlikely return, but we're getting them closer to it. So for those folks who are on drawing traditional UI or PUA or exhausted either of those or met tenure, the next thing we got to look at is at their dislocation job. Was that from a low growth industry as defined by the NAICS? Or was it a low growth occupation as defined by the ONET? In IWDS, those are captured at the bottom of the dislocation job. When you're recording that, you'll load in the NAICS and the ONET, and you see an error, or you see a question declining low growth. If either one of those have a yes, then as long as the person met the previous criteria about UI or tenure, then the system's going to make them unlikely return. And that's the simple logic on that. For those of you who work with Career Connect, again, I'm going to refer you to the Career Connect Zendesk for their tools that can give the details about exactly on how you're going to capture the declining industry and low growth occupation. So now we're going to transition back from Career Connect, and we're going to speak about those jobs where the job wasn't declining or low growth. Well, how are we going to deal with that? Well, in the updated policy, they did a really good job of adding information about required additional assistance. And what this is for is somebody whose job is not from declining industry or low growth, but based on the assessment of the career planner, you can support why the person cannot go back to that previous job. But you as a career planner is the only form of documentation will be your assessment. In the career planning policy, they did a great job of giving some examples of people who could be considered requiring additional assistance. An individual who meets long-term unemployed, which is unemployed 27 or more consecutive weeks. An individual separating from the military, and then it goes on and on. We don't need to read each one of those, but the policy does a really good job, I thought. Now, it's not limited to those. If you have other in your assessment that doesn't fall into this that you're utilizing, it's fine, but these are some really great examples. And where that's captured in IWDS, it's on the Dislocated Worker Characteristics screen right at the top, requires additional assistance. You'll notice that question is not an asterisk item, meaning it's not required to have a response. So I'd encourage you, only respond to the required additional assistance if you need it, meaning if the job was not from declining industry or low growth. Because if you put a yes to that, When a monitor comes out, they're going to expect to see your justification why you checked that. So it's really important that know that if you put a yes to that, you have to have a case note tying why your client requires that additional assistance. And it's on you as the career planner to justify that. It's also important to understand the alternative criteria under unlikely return is related to the questions of required additional assistance to regain employment would only be again needed if the client is not from a declining industry or low growth occupation with their dislocation job. And most dislocation jobs are either from a declining industry or low growth or both. Now, there was a change to our policy in the past for unlikely return. We had these two questions. It's on the dislocated worker characteristic screen of unemployed 6 months prior to application, completed 1 month of job search. Routinely, for years, career planners would check one of these questions and be on the hook for documentation for it, but they had to be answered together to make the person eligible. And there was a lot of write-ups that people had gotten for this issue. So our policy folks did a great thing. They'd taken that portion of the criteria out. So if you have somebody that's long-term unemployed, which is this definition here, somebody that's been employed 6 months with 1 month of job search, they just put it together. You can use that under requires additional assistance. So you no longer have to utilize those two questions. They are still in IWDS. We've got the write-up for our programmers to remove it, but they do not have the eligibility criteria tied to it any longer in the policy guidance. So you'd use required additional assistance in place. So to recap, again, for unlikely to return, which I said is very layered. The first, the person has to be laid off, notified of layoff. The next, they have to be eligible to draw a monetary UI benefit or exhaust it, or they have to met tenure. And then next, we're looking to see if their dislocation job was from either a declining industry or low growth occupation. And if it wasn't, has the career planner been able to justify it under required additional assistance? So that's the portion for unlikely to return that's very detailed. Even though those two questions that are still appearing in IWDS about 6 months with 1 month of job search, as we mentioned again, we would now use that required additional assistance that was addressed under slides 58 through 62. And on that slide 60, it gave that individual who meets that long-term criteria unemployed. So that's what you'd use in place of that 6 months with 1 month job search. So if you understand all those ins and outs of the unlikely to return, the rest of the dislocated worker is so much simpler because that's by far the most complex. So next we're going to move to plant closure substantial layoff. I'm really excited about the changes in our policy, especially around substantial layoff, because it's been really broadened. So let's talk about that. In order to meet the criteria, an individual must have been terminated or laid off or has received a notice of termination or layoff due to a permanent closure of or substantial layoff at a plant, facility, or enterprise. This is any business, so you don't have to think big. Even if it's a small business, they could still meet this criteria. In Career Connect, they have the category 3. So this typo, there's a typo, I just realized it says category 1 within Career Connect. It's category 3 for your plant closure. But one of the things in Career Connect, they have it different for somebody who is who's been notified of the layoff as compared to somebody who is still working as compared to somebody who is laid off. So again, the biggest change though for the substantial layoff is in our policy is the true game changer I feel that we're going to speak about right now. And this is the new wording. In order for somebody to be considered a substantial layoff, if they have their layoff that's resulted from any federal, state, or local disaster or emergency, and this can include flood, tornado, fire, COVID. And if you think about it, a lot of people's layoffs are associated with COVID going on or have in the recent past. You can use that as a substantial layoff. So if you're able to tie that guy who got denied UI because the employer had fought it, how that layoff was tied to COVID, you could record that under substantial layoff. So that's a really good. Now you can't blatantly just make it up. You got to be able to tie it to it. But again, most jobs right now, when they're having issues where they're having to lay people off, a lot that can be tied to what's going on with the economy due to COVID. So also what's added is documented state or local rapid response layoffs in Illinois would be considered, it's in the EB system, would be considered substantial layoff, which is kind of a known. Then this third one that was added, layoffs from sectors and occupations that are substantial or significant to the regional or local workforce or economy as identified by the LWIB. So this is giving your local area some flexibility. Now, in that slide, when I read it at first for policy, I was saying, well, what does that mean? Layoffs from sectors and occupations are substantial or significant to the region or regional workforce. So I'd sent a question to our regional program managers, Kelly Lapatino, Brian Ellis, and Annie Dorr, along with Tamika Chisholm, who oversees monitoring. And they gave me a really good detailed, it was coordinated through Kelly, through all the other folks, but they'd stated substantial sectors and occupations should come from local and regional plan documents. If the occupation/sector is not listed in the local plan, but there are other extenuating factors that the board believes will impact the local economy, they can determine as circumstances warrant to include those layoffs as significant to the local economy. The circumstances should be defined in the local policy along with a statement from the LWIB as supporting documentation for eligibility purposes. What this allows is each of your LWIBs can establish these occupations or industries that you want to be key for your local area. And if anybody loses a job in those can be tied to a substantial layoff. So this, again, adds a lot of flexibility, I think, to help folks who might not otherwise be eligible because they get denied UI or something like that. An example that Kelly Lapatino provided, let's say a company closes or has a mass layoff and it impacts other employers that do business with the company. And then she showed how the company laid off, but it affected another business. So we were able to tie that business also to that substantial layoff. That was a really good example, I felt. So again, other questions. Often I get questions, hey, what is a substantial layoff? So again, that guidance that I just provided. And then also, substantial layoff could be tied to 50% of employees, but that could be broadened. As an example, let's say you have a company that's running 3 shifts and they close an entire shift off. It may equal only 1/3 of employees, but that can easily be justified as a substantial layoff. Or let's say you have a small company and they have a small sales force with just 6 salespeople and they lay off 3 of those. Well, that would be half of their sales force. So that could be considered a substantial layoff. So you can look at these types of details, especially in small businesses. If you have questions of whether or not a client meets the criteria of substantial layoff, I encourage you to reach out first to your supervisor and then to our OET rapid response team. They got a vast amount of knowledge on these types of topics. So reach out to them if you're not sure if something could be considered a substantial layoff. With an IWDS, the logic for determining if a client meets the criteria as a dislocated worker under plant closure or substantial layoff is based on the dislocation job on the edit job screen. And here's another commercial about the IWDS system. When you're recording an application for a dislocated worker, at application, the only job you should be recording is the dislocation job. You're not recording the whole application history of all the jobs they've had. You're just waiting to record the dislocation job. If you record all the jobs, the system could technically make somebody eligible for an old job that you do not have the documentation to support. So again, just record the one dislocation job. The one downside to this guidance is if you bring in a person who had a previous application in IWDS, and you do a new application, it does import all of those old previous employments that had been auto-populated in as well as put in. So it's important to go through and make sure those old ones are closed out so you don't get eligibility determined incorrectly. So it's something to think about, those folks that you bring in that had previous applications. So for a new application, when you're creating the dislocation job, there's a layoff reason. And if you pick either plant closure or substantial layoff, as long as that was the primary occupation of the client, and as long as you have yes to the word dislocation in the application on that job, the system's going to pick that job up as the dislocation job. So that's a really important detail to understand. Again, layoff reason, plant closure or substantial layoff. then the system, as long as you have a primary occupation of yes, dislocation yes, is going to pick that up as your dislocation job. And the expectation is at time of exit, you're going to have that documentation to support that. And also, we have an opportunity to record if somebody is within 180 days of layoff. So they haven't been laid off yet, but they're within 180 days, so 6 months of that, and you have documentation to support it, you can put them in also under plant closure substantial layoff. Again, plant closure substantial layoff is by far one of the easiest ways to put somebody in. Now, in Career Connect for plant closure substantial layoff, I talked about it earlier, there's two different categories, Category 3 and Category 4. Category 3 in Career Connect is for individuals who have already been laid off due to a plant closure or substantial layoff. Category 4 is for individuals who have been notified via public notice of an upcoming layoff due to plant closure substantial layoff. And here are slides about that. Again, Category 3, and again, this is off the Chicago Cook Workforce Partnership Dislocated Worker Eligibility Checklist, and it's used for folks who have already been laid off. And Category 4 is for folks who have been notified, but they're still working. And that's in Career Connect for those of you who use, for those of you from LWIA 7. So now we're going to move on to the newest dislocated worker criteria that I'm probably the most excited about, that I think we could help hundreds, if not thousands of people. I know across the state, we're having a hard time, a lot of local areas identifying folks who are dislocated workers. Well, this new UI Profile E, it does a lot of heavy lifting for you. And what it is if anybody, when they apply for unemployment insurance, the folks at IDS have an algorithm they run, and if they feel the person's going to have a hard time getting reemployed, they profile them. And what they do is they provide extra services. They actually make them come in for an extra services, but they do get extra benefits for it. Well, if somebody is profiled, what's going to make them for WIOA Dislocated Worker Eligibility, it's going to make them automatically eligible as long as when they apply for WIOA, it's within 1 year of being profiled. The system is going to have that information. It's going to auto-populate in, and the only thing you're going to have to prove is that they're authorized to work in the United States, and if they were born male, that they're compliant with selective service. All the rest of the eligibility is within the system. You won't have to have them, you won't load a dislocation job, you won't have to make them bring in documentation to prove UI or if it's a declining industry. It's just by being profiled. So this is a really great way, and this is how it's going to show up on the employment characteristics. When you build the application, you'll notice down towards the bottom, it won't be highlighted in blue. I did that just to draw attention. You'll see it speaks about UI Profile E dates. If it's within 1 year of their WIOA application, as long as they haven't obtained full-time self-sustained employment, but why would they be coming in to get services if they had? They're going to be eligible as a dislocated worker under UI Profile E. As previously stated, they must have been profiled within 1 year of the date of their WIOA application in order for this to get picked up. The next few slides demonstrates how it's going to look. After the person's completed their application's been profiled, you'll notice they'll just show up. They're eligible as a dislocated worker, career services, UI Profile E. You can look at documentation criteria. The criteria explains the whys. So they had to be authorized to work in the United States, they had to be compliant with selective service, and they had to be a UI Profile E. If you click on each of those individually, it explains what those mean. So I'm going to click on UI Profile E, and it just gives the explanation of what it meant to be a UI Profile E. And that's in the IWDS under the criteria. Now for documentation, so you'd have to have the choice of documents that's used, and this is out of Attachment A, which are the source documentation requirements. Then if it's born male, they have to support selective service. And then for UI Profile E, you can use auto-populated verification of the UI Profile E status, which I highly recommend. Or if you're one of them people that like hard copies, you can actually get a UI Profile E list out of IWDS that'll have all the folks who are profiled of the reports. But to me, why not just use that auto-population verification of UI Profile E status that's right on that employment characteristics screen. So this is a completed certification for the dislocated worker UI Profile E for a female client. So it was not applicable for selective service. certify it, and then they're eligible to be enrolled in services under any of the dislocated worker, 1D, 1E, 1N, 1S, 1DC, 1EC. So that is so much simpler than anything else you're going to find as a dislocated worker than be able to find folks that are UI profile lead. So now, for those of you who work with Career Connect, at the current time, Career Connect doesn't have this eligibility, the standalone eligibility for UI profile leads. However, every individual that has been profiled by the Illinois Department of Employment Security within LWIA 7 boundaries should still meet the WIOA dislocated worker criteria under unlikely to return to previous industrial occupation, which is captured under category 1 within Career Connect. So they should still meet that. They just have to do bring in a lot more of that documentation where they have to prove the UI and is the job declining, industry or low growth, or they require additional assistance. So again, and they're working on updating Career Connect, but until that's updated, you have to use, for those who work Career Connect, use the category 1 for those individuals. Now there's a report in IWDS that I highly encourage everybody who works each LWIA to be on top of this and run this report on your own to identify those folks who have been profiled. So I'm going to kind of show you where that's at. It's on the reporting menu, and it's under the participant levels. You just click on UI profilee, and then you have the LWIA, and you can pick a start date and an end date. I did this recently for all LWIAs. I did it yesterday, just to get the total numbers of people that's been profiled. So here's how I've set up the criteria. I put it under those who began getting profiled as of March 1st, 2022, with end date of 2/28/23. So just short of a year. And this was out of the test system here. I didn't want to provide real client data, but when they profile, you're going to get their first name, last name, their address, their zip code, their phone number, their profile date, as well as their email address. This information, again, it's on the screen print. It's due to the protection of PII. I didn't want to have real data on this, so it doesn't have emails. But for your report, it's going to have the emails also. And these should be good contact information because it's what the client is giving the folks at IDS, and IDS is giving them money. So they should be having good contact information on this UI profilee reports. And again, I highly encourage those who work with the UI or work with dislocated worker, you have to be on top of this report because it's an excellent resource to find folks that we know are qualified as dislocated workers. You could set up an outreach program, maybe do a targeted email or direct mailer blast, followed up with phone calls to it. And again, I ran it on all LWIAs, and here's the numbers. So you can see, and again, this was just as of yesterday, LWIA 1, 628, LWIA 2, 312, LWIA 3, 536, and it goes on down the line. So every LWIA has a bunch of folks that are UI profilees, and all these people that's signified by these numbers, as long as they haven't obtained full-time self-sustaining employment, as long as they're authorized to work in the United States and they're compliant with selective service, would be eligible for WIOA dislocated worker services. So you're talking over 17,000 people that's out there right now. It is recommended your LWIA's UI profiling report be ran approximately every 2 weeks, as there is a data lag on when the individuals appear on the report as compared to when they had been UI profilee. Typically, the clients that will appear on the UI profilee report are approximately about 1 month from the date of beginning being profiled as compared to the end date of the report. As an example, on that report I ran, I had an end date of 2/28/23. Most LWIAs, the last date somebody was profiled was 1/23/23. There was a couple that had folks that had been profiled as of 1/30 and 1/30/23, and a few was the week before 1/16/2023. I can only think that some local areas UI are faster at getting profiled than others, or getting that information uploaded so we can have it imported into IWDS. But bottom line, anybody that shows up on your UI profiling report, if they put a WIOA application in, it's going to bring that information in about their UI profilee, and they're going to be eligible as UI profilees, the dislocated worker. As mentioned again, the UI profiling must be within 1 year of their WIOA application date. and you are not required to record the dislocation job, and the eligibility documentation used to support the client was profiled is auto-populated in, so it should make it super easy to help these folks. Again, in Career Connect, you'd have to use that category 1 under unlikely to return for these folks at this time. And that's what the category 1's listed. So now we're going to move on to the title. It's called No Longer Self-Employed. Previously, it was formerly self-employed, now unemployed, but we've changed the name just to No Longer Self-Employed. It's got to be the person's primary job. They can't be doing something on the side and close that down and get services from that. And also for this criteria, they had to close the business due to general economic conditions or flood or natural disasters, and COVID is a natural disaster. Or they have to show the business has evidence of conditions to support it's going to fail or it's on its process of failing. So it's not for folks who have a business and they decide they want to sell it and move on to something else. It's got to be they show they closed due to economic conditions or there was some sort of other issue related to a flood or natural disaster. So how it's captured in the IWDS system, it's based on the layoff reason and the self-employed. So it has to have a primary occupation, yes, a dislocation, yes, self-employed has to be populated, yes, and then general economic conditions or flood or natural disaster. Those are the internal logics that's looking for the system to pick that up. So that's how it works in IWDS again, or for the folks who are in process of going out, it would have those same things, but the employment status would be still employed, layoff pending, and then for layoff reason, it's in process of going out of business. Eligibility for this title could also be met if the individual worked at a farm, ranch, or a fish hatchery where the business closed due to general economic conditions or in the area or a natural disaster. This is documented with an IWDS on the edit job screen. And what it is, there's another question, family member or farmhand, that would be populated with a yes. And, you know, for so long, I had a hard time finding anybody that met this. And not that long ago, right on the border of Illinois and Wisconsin, there was a ginseng farm that closed. And it was a flood that went through and they flooded out the crop. And I was told that it takes 7 years for a ginseng crop to regenerate. So the folks who had worked for that ginseng, a lot of them lost their jobs. So that's an example of somebody who would have been a family member or farmhand that could have utilized this eligibility criteria. In Career Connect, it's under category 5 for folks who have been self-employed that you would capture that. Next, we're going to talk about is displaced homemaker. A displaced homemaker, the key about that is understanding this definition. And it's for individual to meet eligibility as the criteria as a displaced homemaker, they must have been providing unpaid services to a family member and who has been dependent on the income of another family member but is no longer supported by that income and is unemployed or underemployed and experiencing difficulty or upgrading employment. At one point, if you look in the WIOA definition in the glossary of terms, as well as in the WIOA legislation, in that definition that I provided in that slide, the formal definition put a great big paragraph about people that were married to people in the armed forces as part of a displaced homemaker. Well, then they end up making a whole separate category for dislocated worker about folks that are in the armed forces, married to armed forces members. So myself, you could use it either as a displaced homemaker or spouse of an active duty service member for folks that fall into that. Myself, I would use that spouse of an active duty service member since they have their own criteria, but they would meet both the displaced homemaker as well as the service member that we'll spoke about in a moment. But back to the traditional displaced homemaker, it's captured in IWDS by the question of displaced homemaker. If it's populated with a yes, the system's going to make the person eligible. But it has to, the career planner has to know that definition, and then the client would have to provide the documentation to support that. And it could be a number of different circumstances, but the most common examples of displaced homemakers is typically an unemployed or underemployed spouse who gets a divorce or separated and cannot afford divorce from the primary earner of the family, or an unemployed or underemployed whose spouse was the primary earner and had passed away. Or another one is unemployed or underemployed spouse where the primary earner in the family lost their job. those are the three most well known for those. On this, there's some other examples I've heard over the years for training, like maybe you have an adult child who quits their job and goes to take care of an ailing parent and is supported by that ailing parent, and that parent either gets better or passes on. And they said, could that work? Well, it meets that definition, and it seemed to, you could work that. But again, they have to know that definition and how the client met. And I'll just go to that definition one more time. It's somebody who has been providing unpaid services to family members and who has been dependent on the income of another family member, but is no longer supported by that income and is unemployed or underemployed, experiencing difficulty in obtaining or upgrading the employment. On this for documentation, and it's going to vary depending on the client's circumstances, but at a minimum, you're going to have to support that the client themselves was either unemployed or underemployed. And then based on the scenario, if it was a divorce, it's the court order. If it's a death of the primary owner, it'd be death certificate. If it's self-attestation, if it's a marital status where they're separated and they cannot afford to get a divorce. The other circumstances, if the primary breadwinner had lost their job, maybe it'd be the layoff letter of the spouse. One caveat I do want to pass on that I'd heard recently in a training is we had a local area that put in the spouse of somebody who lost their job as a displaced homemaker. And they were still married to that spouse. And so we had basically both clients in. You had the primary client that lost due to plant closure, and then the spouse came in as a displaced homemaker. Problem was when the spouse that had lost their job due to plant closure was reemployed, that client that the LWIA put in as a displaced homemaker decided that they didn't want to work. And they dropped out of their training program and they said, no, I'm good now. So I'd highly encourage that question to be asked if you're going to put a displaced homemaker in that's still married based on their primary breadwinner losing their job. Are you definitely wanting to work even if your spouse gets back to work? Because if you put those folks in your dislocated worker, you're on the hook for their performance outcomes. And if they choose no longer to participate and you put them in training, you're going to lose the credential as well as employment. So just some food for thought. In Career Connect, this is captured under category 6, and it's got the checklist for that. And it's just basically very similar. You really have to know that that definition of a displaced homemaker. The last title or portion of the dislocated worker is spouse of an active duty service member. And this was added in. It wasn't part of the previous WIOA that was around from 1998 to 2015. It was only brought in for WIOA, and it stays. And it's a really good program that if somebody's married to a member of the armed forces and they had to lose their job due to duty transfer to follow the spouse, then they would be eligible. But it also includes just a straight up criteria that if you're married to somebody that's in the armed forces and you're unemployed or underemployed and experiencing difficulty in obtaining or upgrading employment, you're automatically eligible as a dislocated worker. So we have two local areas. LWIA 1, they have Great Lakes Naval Center. It has literally thousands of active duty service members. And down in LWIA 24, we have Scott Air Force Base that has literally thousands of active duty service members. In each of those cases, if they have a spouse that's unemployed or underemployed, that would make them eligible as a dislocated worker. For those of you who aren't near a base, every town of reasonable size typically has armed forces recruiting offices. So any of the recruiting offices that have spouses that's unemployed or underemployed. A lot of the colleges have ROTC units that they have active duty service members at. So anybody that's married to those. So those are some other ideas for going out to find individuals who would meet the spouses of an active duty service member potentially. The logic for determining eligibility, you don't record a dislocation job. It's all on the dislocated worker characteristics screen. It's the question, spouse of an active duty service member. If that's populated with a yes, then one of these other two questions, employment loss due to relocation, or unemployed or underemployed experiencing difficulty in obtaining or upgrading employment. If either one of those are also marked with a yes, IWDS will determine that person eligible as a spouse of an active duty service member. To qualify as a dislocated worker spouse and active duty service member, then the spouse either had lost their job due to the relocation from a transfer of a duty station, or the spouse is unemployed, underemployed, and experiencing difficulty in obtaining or upgrading employment. At a minimum, the documentation would include that military ID card that shows that they're a spouse of an active duty service member. And then if they lost the employment due to the spouse being transferred, you have them bring that transfer orders in would make sense, along with the work history. If the eligibility was based on just the spouse being unemployed or underemployed and having a hard time finding employment or upgrading their employment, you just have the client's military identification card showing their spouse's status, and then that work history supporting the client's unemployed, underemployed. In Career Connect, they actually have two different categories. You have under Category 7 and Category 8. Category 7 is for folks who had lost the job due to their spouse relocating. Category 8 is the folks that are married to a person in the armed forces that's unemployed or underemployed and having difficulty in obtaining or upgrading employment. And this is just the screen print of the Chicago Cook Workforce Checklist about Category 7, as well as Category 8. So this concludes the various ways an individual could meet WIOA dislocated worker eligibility. Again, there are now 6 different ways an individual could meet WIOA dislocated worker eligibility, and each of the criteria is significantly different. Again, we have unlikely to return to previous industrial occupation, plant closure, substantial layoff, UI profilee, no longer self-employed, displaced homemaker, spouse of a member of the armed forces. Again, often people that will be eligible for more than one category. You'd want to certify in what's easiest for the career or for the client themselves, that's least restrictive for documentation, as well as what's easiest for you as a career planner. So again, anybody that's a UI profilee, you definitely should be using that because it's going to be so easy. It'll just auto-populate in. The folks who are plant closure, substantial layoff, that's much easier than unlikely to return because plant closure, substantial layoff is just based on their circumstance. It doesn't look at those things like unlikely return does, where they have to be on UI or exhausted UI or met tenure. Then you have to look at the dislocation job. Was it from a declining industry or low growth? Or did you support it and requires additional assistance? So there's so many more layers in the unlikely to return. So again, these 6 are there. Use what's best for the client as well as for you as the career planner. Within the updated WIOA eligibility policy that was released on January 27th, there are 2 changes that should hopefully have significant impact in assisting in identifying as well as finding those new WIOA dislocated worker clients. And that's the updated / broadening of what could be considered substantial layoff. This could be a real game changer, especially depending on how your local plans are written up, but also identifying those folks that lost their job due to COVID. That's going to make them automatically a substantial layoff. And then again, that new standalone WIOA dislocated worker eligibility for those individuals who have been profiled within 1 year of the date they apply for WIOA. They're basically automatically qualified as long as they're not currently working in self-sustaining employment. You could set up, like I said, a direct mailer. That report can come out, can be in an Excel that comes out of IWS. You can make mailing labels off of it. It's a great resource for doing an outreach if you do a telephone blitz, ever how you'd want to utilize it. But there's over 17,000 people that's been profiled that we know should meet eligibility as a dislocated worker right now that's on those reports. So this concludes the presentation. So now we have time to open it up for any questions and to make sure we get all answers for that. So Kirsten, do we have any questions up there?
Yes, we do. 1 second. Let me just review them here. We have a question of what would that backup documentation be?
So which question? Because we've got a lot. So
we also have a question of how would we confirm their tenure from an employer not paying into the UI system?
We can definitely deal with that one right now. A good way to check the tenure is if you check an IBIZ for somebody and they'd say, hey, yeah, I've been working at this job for whatever period of time. If you run an IBIZ and they have no job showing up or that job showing up, you'll know that's a tenure. Now, the IBIS does have a little bit of a data lag, so you could actually also probably ask the person on their for their employer's information, and you could do a little reach out to find out if that's a job. Again, it's typically going to be, there's probably, and this is a total guess, but I would say probably less than 5% of the jobs out there do not report wages, because most of our jobs report wages. So for those, if you think about the exiters on the backside, these are people that are supplemental. That's how we capture supplemental wages. So you probably get an idea of what employers don't pay into UI. It's going to be a very limited. So you're looking at a lot of the small businesses, people working for farmers, working for maybe some non-for-profits, but definitely like churches, religious organizations. So, but again, if they said they've worked there for a while, if you're running IBIS, if it's not showing up on IBIS, you'll know that's a job that did not report wages.
Okay, great. Thank you. The next question is asking for clarification. If they are receiving workers' compensation, they can be determined eligible under the 10-year criteria, even though they do not have a layoff date?
Nope, that's not what it stated. What I'd stated is if they're on workman's comp and then the company lays them off, because I had a case study question. That's what happened. A guy was on workman's comp and then the company laid him off, and they want to know if they could make the guy a dislocated worker. Well, if he's been formally laid off, then yes, it would. That's what I want to make sure in that circumstances that it was a layoff. It wasn't, they were just on workman's comp. So no, not just being on workman's comp. What I'd said is if somebody had been on workman's comp and they get laid off, since nobody had paid into UI on their behalf, that would make those folks would have met that 10-year criteria, because they wouldn't be able to draw a monetary UI benefit.
Okay. But
thanks for asking that. That's sure it's clear. I appreciate you clarifying that.
Yeah. The next question is, when is the case note for requires additional assistance entered? Summary of assessment.
Right
when is the summary of assessment entered in a loan case note?
Yep, that's a great question, and thanks for asking it. Well, you have to have it by the time you certify eligibility, because you're going to say yes to that required additional assistance as part of the application. And then at certification, that's when you have to support the criteria you listed. So the expectation for whoever is going to review your record would look at your certification date. So let's just say you certified a client today, the 1st of March, and you said yes to requires additional assistance. Well, then that case note should be dated either today, the 1st of March, or prior to. It wouldn't be dated later, because we're saying that we utilize that. So whatever date that you're saying that you're certifying the client, it should be on or prior to that case note. But that's a really good question. Thanks. It's the first time I've had that before. So probably add a case note or a case study for my in-person training for that question. So good. Next one.
Are all customers on the IDES RESEA list considered a UI profile?
I don't know what that list was, we had mentioned. All I can tell you for UI Profile E, it's the list that's out of IWDS. You can run it by WIOA, and if the client has been profiled within 1 year, and they come and put their application, they're gonna get auto-populated in. So I don't know what that other list was you're speaking about.
Okay. What maybe Christine could clarify. A follow-up question is, how frequently are the names who are UI profiled downloaded into IWDS?
That's a really good question. It's got that, as I mentioned, that data lag. And when I was looking at that yesterday, as I mentioned, I ran it for all LWIAs, and some had the last date updated 1/16, some last updated 1/23, some last updated 1/30. So they do imports to IWDS on a every couple weeks basis, but it's going to be based on when the folks at IDS had done that profiling. And it looks like some LWIAs do it quicker than others just based on the last date. But for all LWIAs, the latest was 1/16 when I put that date of 2/28, and the most current was 1/30, so January 30th. So those LWIAs that had for January 30th, you're only looking about a month. For those others, it was a month, 5 to 6 weeks that data lag is. So myself, I would run that UI Profile report now for the whole year and get that first list. And then after that, you just want to run it every couple weeks with a current date, and that way you can capture those people that get more frequently profiled, or that have been more frequently or currently profiled. Because if you think about it, if somebody was laid off and profiled a year ago, good chance they've got a job now. But those who are profiled recently, well, these folks should be right in the job searching mode. But it's worth reaching out if you're having a hard time finding dislocated workers to that entire list to start out with a direct mailer or an email blast just to get it out there to let these folks know what you have available. And again, their eligibility is going to be so easy. So, and this is something I'd also encourage any LWIAs, if you have a tool that you're using, say you put together a direct mailing email or a letter you're sending out, please set it up and share it so we can share it with our other LWIAs so they can tailor it for their own. Or any other tools that you're utilizing to do an outreach that you found successful, please share it with me, and that way I'll make sure to pass it on to the other LWIAs.
What document do we use to confirm that they are a UI profilee?
Well, two different things. You can run that report out of IWDS. That's how you'll know who's been profiled within your local area. And the other is when they put their application in, it's going to get auto-populated in on that employment characteristics screen. But your hard copy document would be your UI profilee list that you get out of IWDS off that report that I demonstrated.
For UI profile, will this auto-populate in IWDS?
Correct. Yeah, for everybody that's on that list. Now, see, not all those people will have applications in. Only people that's going to have applications in, there's people that have applied. So the report lists everybody that's in the particular LWIA that's been profiled. Then as you reach out to those people, or if those people would come into your office, when you put their WIOA application in, you'll see on the employment characteristics screen down at the bottom that their profilee date will get auto-populated in. But for your first outreach, you definitely want to do that report because if not, then you're just waiting for people to show up and hope they're profiled. So you can be proactive by getting that report, doing outreach to those folks by knowing that they are eligible as dislocated workers.
Does a UI profilee have to still be receiving UI?
Well, they're going to be receiving, but you don't have to have documentation on that. No, they don't have to be. Just by being a UI profilee, because those who have been over 6 months since they've been profiled, they're probably going to be exhausted their UI, but that's not going to have any eligibility criteria tied to the UI profilee. Their eligibility for UI profilee is strictly based on them being profiled. So, but fine if they're still drawing it or if they're not drawing it. But for your eligibility purposes, they're going to be eligible regardless either way.
If someone is on the UI profilee list but has sustained full-time employment, can we still serve them as 1D and use the list as an automatic eligibility criteria standalone?
The system would the system will let you do that, but that's not the best use of your dollars. You're bringing in somebody that's already met full-time self-sustaining. So just because they met the eligibility, you probably wouldn't want to use your dollars to serve somebody that's already in full-time self-sustaining employment. But for sure eligibility, the system is going to make them eligible. But I would think when monitoring came out, if they started seeing that, hey, these people are already full-time employed, when you put them in, why do we use our dislocated worker dollars for that? But for sure eligibility, yes, the internal logic in IWS is going to make that person eligible.
Can we use
profile within 1 year?
Okay. Can we use the IBIS printout for documents?
For what are we trying to use it for? You won't be able to use it for UI profilee, but for somebody who's unlikely to return, yes, you definitely would need it to support the receiving UI or the exhausted UI. You could also use it for the dislocation date. One of the things, and I don't know if it's happened as much now as in the past, something I'd found in the past, that when we'd pull up an IDS dislocation date didn't always match what the client had stated, because the IDS folks might put in a different date for some reason. And sometimes it was even dates on weekends. I don't know if it was a typo or what happened. But for WIOA application, you could use that date that's an IDS for the dislocation date, or you can even use the client's self-attestation on it. But it depends on what criteria you're looking at. But for UI Profilee, you wouldn't be using anything from IDS. It's all based on either the UI Profilee list or that auto-populated in UI Profilee.
Okay. Can we get a list of UI profiles for outreach purposes?
Yep. Your own LWIA, let me just back up the slide so where we did that. Yeah, for each LWIA, everybody who has the ability to run reports out of IWDS. And if you don't, if you're a career planner that works with the dislocated worker population, you'd have to ask your local systems administrator to have the ability to run participant reports. And again, for those of you who use IWDS, you would go to the reporting menu. For those of you who work Career Connect, I would encourage you to work with your regional program monitor or manager with the workforce partnership, and they could run this for you if you don't have the ability to run it. It makes it a little more challenging for you folks with LWIA 7 because it's breaking it out by all LWIA 7. And if you looked at the sheer numbers, and again, just to show the demonstration how you can run a report, you click on it, you buy LWIA, you put a start and end date of the dates you're wanting the report to run by. The system brings up the report. And this example is out of the training IWDS, but it's going to give you the name, address, city, state, zip code, phone number, profile date, and email address. And it gives you the number accounting of how many folks show up. And again, I'd ran these reports as of yesterday using the date range of 3/1/22 through 2/8/23. And for each of the LWIAs, this is the numbers that's showing up right now that has actual names, phone numbers, email addresses associated with every one of these numbers that's on that current UI Profilee list. So for LWIA 7, you guys will have to figure out how the best way to do it since there's one report and it's for the whole area. But you need to find some way of doing outreach to all 5,600, 5,679 to find out if they're interested in getting some WIOA dislocated worker services.
Okay, how is this different from the 3-year look back?
Two different things. The look back is something that a local area can have. In the WIOA legislation, as well as the WIA, there was no look back period. And what a look back is, if a local area establishes it, that's how far back you can go for the dislocation job. So if your local area had a 3-year look back, it was just saying your dislocation job had to be within the last 3 years. Well, the UI Profilee, you're only looking for people that's been profiled within the last year. So it wouldn't ever impact any sort of a look back period.
Okay. Would displaced homemaker be an option if the family member was a life partner without the benefit of a legal relationship?
Nope, it's because under WIOA, it goes by that family definition, which is it's based on marriage. So in this, if it's life partners, if there's not the formal marriage, you wouldn't be able to. You're on the hook to follow the WIOA guidance about family. So you'd have to utilize that.
Okay. Is a UI Profilee still automatic eligibility if the customer has part-time employment that is not self-sufficient?
Yes, that's excellent. I appreciate that question being asked. Yeah, because that person would be underemployed. So as long as they're not full-time self-sustaining employment, yes, most definitely. If they've been profiled, you should be wanting to swipe those folks up because it's showing they're wanting to work. They're just having a hard time finding that full-time self-sustaining employment. So most definitely. Only people that wouldn't be eligible or shouldn't be served under UI Profilee would be somebody who's already resumed full-time self-sustaining employment. And again, that's where you have to know your local area's criteria for what makes somebody self-sufficient as a dislocated worker.
Okay. How do they obtain the UI Profilee list? We already covered that, didn't we?
Kind of covered. Yeah, we
Yeah.
covered that one. It's a participant report. And for those of you who work with Career Connect, if you don't have access to IWDS, work with your Cook County Regional Program Manager, and they'll be glad to help you, I'm sure.
Okay. The next question is, can a resident of Illinois who received PUA in the state of Indiana be eligible?
Yep, if it's exhausted. That's the key, is have they not had full-time self-sustained employment since it's been exhausted? So not knowing how Indiana had done their PUA program in Illinois, we ended it in September of 2021. So if somebody had a balance or they exhausted as of September 2021 and they have not obtained full-time self-sustained employment since then the appropriate answer would be exhausted UI, and it would be that PUA. But if that person had went out and found another job, full-time self-sustaining, then that wouldn't be relevant. So not knowing when Indiana had quit or stopped using PUA, but we could still utilize theirs as long as they've received it or exhausted it and have not had full-time self-sustained employment since.
Okay. Two more questions. Can underemployed be a standalone eligibility factor if it's not related to the wage percentage, but stating the training received would allow for a greater employment opportunity if our workforce board has a policy stating this? Also, customer needing additional assistance cannot be a standalone eligibility factor.
So there's two questions. I'll do the first one that was last asked. Require additional assistance. That's only portion of criteria as part of dislocated worker unlikely to return. And it's only after they met those other categories of eligible for or exhausted unemployment or met tenure, and then the job wasn't declining or wasn't from a low growth, the dislocation job, that's when requires additional assistance. So it can't be used standalone. It's only part of unlikely return. And back for underemployed, that can't be a standalone criteria. They have to meet one of the eligibility criteria, which underemployed is part of your definition under displaced homemaker and spouse of an active duty service member. But if somebody is underemployed, they still would have to have that dislocation job in order to meet the criteria, unless they were a UI profilee, displaced homemaker, or spouse of an active duty service member.
Okay. And the last question is, would a person who has a layoff or termination notice from an employer but doesn't apply for UI still be eligible for DW? In other words, does DW, dislocated worker, have to apply for UI?
That is an awesome question. And whoever sent that, I'd like you, if you could email me to my james.potts@illinois.gov. Could you send that question to me in a written form? Because I want to turn that into a case study question. Because our policy requires, or this is not our policy, it's in the federal guidance, that for somebody to be unlikely to return, they must be eligible for or exhaust unemployment. But it allows somebody who's been laid off, or excuse me, who's been notified of layoff to apply for this. Well, a lot of times you have not applied for unemployment. So how do we have to deal with this? So at this point, I want to get that question, whoever had asked it for me, and I want to route it through our policy folks, and if necessary, even DOL, to get our final answer on that. Because this is, and I've been doing this since '06, and I've always wondered this question, but nobody's ever asked that. So who knows that person that asked the question? And since I don't have an answer, because I've never dealt with that, please send me that question and we'll research it and we'll get you the appropriate answer. And then we'll share it with everybody else that was on this call too.
Great.
And any future hands-on in-person trainings, we'll make sure to cover that too. So again, thanks for asking that question.
Great. Okay,
That's the last one, because that was a great one to end with.
Yep, that was the last one, and we have about a minute left. You want to go ahead and wrap us up, and then I'll do my ending housekeeping items.
Yes. Just one quick commercial. We have a career planning policy that's been out there since December of 2021. There are a lot of requirements that's in that career planning policy around recording assessments, using the assessment summary section for those who use IWDS, that not all cases have been done. Please, and also that career planning policy addresses case notes, how there has to be topics in the category subject line. please, if you haven't read that, get in that career planning policy and understand those requirements, because when you're going to get monitored on it, they're going to expect you to be following that guidance in the career planning policy this next monitoring cycle. So please, besides Dislocated Worker Year, if you're not familiar with that career planning policy that came out in December of 2021, please get into that so you can start following it so you don't get yourself some write-ups. That's all I have. So I appreciate all of your time today. As Kirsten said, she will post this, the recording as well as the PowerPoint. It's going to be out there within 24 hours. And then again, if you have questions, feel free to send them up, especially these off-the-wall questions, not necessarily off-the-wall, but that you need answers to, that I like to use those to share with other folks who may have not asked those questions, but had that during my in-person training. So appreciate all your time and have a great remainder of your day.
Thank you so much, everyone. Just to wrap us up, I did go ahead and put the follow-up survey in the chat. If you have a brief minute out of your workday to take that follow-up survey, we would greatly appreciate it. And then in your follow-up email tomorrow will be the URL link where the policy is and the slide deck from today. I'm going to go ahead and put that in the chat though right now because I know somebody asked for it. And so both of those documents are on that website, and they're also on Illinois WorkNet too. So if you're not as familiar with our website, they should be on Illinois WorkNet within that 48-hour time window, just to clarify. So it usually takes us about 48 working business hours to get up the recording, but the slide deck and the policy should be up within about that 24-hour time window. And I already have it up on our website right now. So just for clarification. And again, all of these things will be in the follow-up email tomorrow. So you'll have it in that one-stop shop. And if you need anything else, please feel free to reach out to Jim or myself. We're happy to help you. And I think that's it. We can go ahead and close out for the day. Thank you so much, everyone, and have a great rest of your Wednesday.
Thanks, Kirsten.